Hello, everyone. I'm Leslie Rohde, and welcome to Ask the Lawyers. Today's topic, how to enforce a custody or a support order after divorce when one person moves out of the state or out of the country. Our guest today is attorney Kelli Byers Hooper. She joins us to shed some light on this issue. Kelli practices divorce and family law in the greater Atlanta area. She has offices there in Atlanta and in Fayetteville, Georgia. She's also the chair of the Child Support Committee for the American Bar Association. Thanks for taking time out of your day with us today.
No problem. Good to see you.
Well, just let's talk about some of these issues that come up sometime when one person after a divorce moves away, moves out of the state. What issues are we talking about?
Well, generally, when a divorce is completed, the parties contemplate that they're going to be living wherever they were during litigation. So generally it's in the same county or at least in the same state. Oftentimes folks will get, a job offer, or they'll, marry someone that's in the military and have to move or something like that and end up leaving the state. And usually the biggest thing that happens is we have to adjust visitation arrangements, right? Because the visitation order will generally have, folks meeting at the kids' school or meeting at the, Kroger down the street. Well, that's not really practical when, daddy lives in Alabama now and mom's in Georgia. And so generally we see orders needing to be adjusted or modified in that instance.
And that was going to be my next question about those modifications. Can you modify these after people move, and how do you do that?
Oh, absolutely. So here in Georgia, as soon as one party leaves the state, that's grounds for an automatic modification. Because the courts recognize that once one party leaves the state, generally things like child support, visitation, holiday time is going to change because you've got a significant distance between where the parties, are residing. I've had cases where, dad moves to Florida or moves even further, and the order says that they're supposed to meet, at the QT down the street for visitation. Well, obviously, if mom's still in town, that's great for her, but for dad to have to drive across the state and back to the QT to exercise visitation really doesn't work.
Does enforcement change at all? I would imagine it would, because you're dealing with two different states at this point.
Well, sort of. So the order would stay in the state where the child resides. There's a uniform statute called the UCCJEA, which is a uniform statute across most states that governs how jurisdiction would attach and what happens when you have a multi-jurisdictional case. But generally, enforcement continues to happen in the jurisdiction where the original order was entered. So let's say, for instance, if you have a Fulton County order and dad picks up and moves to Miami and the child still remains here in Georgia, well, that would continue to be a Georgia case. Things get a little more tricky when the child leaves the jurisdiction. Then you have to figure out which state has jurisdiction over the any modification or change of the custody order.
So what kinds of things are we talking about when we're trying to figure out if a child is in one place and another spouse is in another? How do you know which state laws take precedence in this?
Well, it's a fact-sensitive inquiry. You have to look and see where the issuing jurisdiction is. Then you have to look and see how long the child has been out of the jurisdiction, with whom they're residing in the other jurisdiction. So there are many factors that go into an analysis under the UCCJEA to determine which state has jurisdiction. There's an affidavit that has to be filed. It's a pretty complicated sort of maneuver. And so I would suggest that anyone that is looking at that issue consult with an attorney who's well-versed in a multi-jurisdictional custody case.
So what happens if one spouse moves to another state? Does that spouse need to get a lawyer from that state in an instance where we're looking at an order like this?
Well, it depends. It depends, again, on where the child resides and what they're trying to do. Oftentimes, you see cases where we're talking about custody, right? And so my general rule of thumb is that custody follows the kid. So if a child leaves the jurisdiction where a order has been entered, then you're looking to see how long the child has been in the new jurisdiction and whether or not a new order would be entered in that particular area. The other issue is for, let's say everyone lived in another state. So let's say everybody lived in New York, and then the entire family then, maybe not together, but everyone ended up here in Atlanta, which happens a lot. So you have maybe a New York custody arrangement, You have New York child support order that now needs to be enforced in Georgia. That's a whole nother maneuver. And sometimes that would be advantageous to a parent who's paying child support because New York child support continues until the child is 21, and here in Georgia it ends at 18. So there may be an advantage if everyone has moved from one jurisdiction to Georgia to domesticating your order so that it becomes an order of the new jurisdiction. Again, talk to an attorney. This is sort of sophisticated lawyering that's happening.
Yes, and in every state, things are different, I would imagine.
Yeah, and so it really does. I tell my clients or prospective clients to come in with their old order. Let's take a look at it. Let's, look at all the facts and circumstances, and then we'll figure out the best way to either incorporate a foreign order or to enforce an order in a foreign jurisdiction. And by foreign, I just mean either domestic or international, because the same thing applies for if, it's an order from another country.
Mm-hmm. And I was going to ask about international cases. Do things get even more complicated when one of the spouses moves out of the country?
It depends. It's like the lawyer's favorite answer there. It does depend. It depends on whether it's a country that has signed on to the Hague Convention, which is an international treaty that governs international custody matters. It depends on whether or not everyone's coming from a foreign country to the United States, right? So in that particular instance, you just get a certified copy or what's called an apostille of the order from the other country. You domesticate it here in Georgia, and then Georgia can enforce that order. If you're going outside the state and you're trying to enforce an order or even a child support order for a payer parent who's living outside of the country, there are lots of things that go into it. You have to look at international treaties, figure out what the country is, and see whether or not it's enforceable. Again, sophisticated lawyering. Don't try that at home. You need to talk to an attorney.
And an attorney who specializes in this, too.
Yeah, don't get anyone who dabbles, because they might not get that right. You need to go with someone who's done this before.
And if someone is bringing a custody order from another country and they're bringing it into the U.S., is it the same thing apply? It depends?
It really does depend.
Okay.
So what you first need to do is oftentimes get it translated.
Oh.
And then you get a certified copy. Well, you get a certified copy, then you get it translated, get a certified copy of the translation, then you domesticate it in Georgia, and then you can file a petition to modify it if you want to here in Georgia. Complicated, four-step process.
Four-step process. Give us just some overall things that people should be thinking about if they're looking at some of these orders, or possibly they're in a situation like this and they've already got an order on the books and one spouse is thinking about moving. What are some things people should think about?
Well, the first thing I tell people to do is to look at your order. Some orders will say that you need to consult with the other party before you leave the jurisdiction. Sometimes it just says that you have to give 60 days notice. So in that particular instance, check your order, see what it says. I've had cases where people have come to Georgia from Florida, and when they leave Florida, they've had to go to the court and get permission to leave the state with a child. And then there's language in the order about whether the new jurisdiction is going to take over the case or whether it's going to remain being a Florida case. So you've got to, all points of inquiry start with your original order. What does it say? What did you agree to?
And then, as you've said throughout, find a lawyer that maybe can help you interpret some of this and find out the details and what would happen if you move to a certain location.
Right, and understand if you're here in Georgia and you leave the state and you have a Georgia order, as soon as you leave the state, that's automatic grounds for a modification of the custody order.
All right, Kelli Byers Hooper, thank you as always for shedding some light on this topic for us. We appreciate it.
No problem. Thanks for having me.
Have a great day. And we want to thank all of you for watching this Ask the Lawyers episode. Reminder, everybody, subscribe to our YouTube channel so you will not miss another episode of Ask the Lawyers. Thanks for watching. I'm Leslie Rohde for AskTheLawyers.com, where you can find a lawyer that lawyers choose.